Hi, good afternoon, good morning, good day, wherever it is that you're watching. My name is Lydia Rincon. I am a senior attorney at Nevada Legal Services. I am up in the Reno office and I am part of the Senior Law Project. Our project, our goal is to assist as many seniors as possible in the state of Nevada. Currently, I focus on the rural counties up in northern Nevada, plus Washoe County. And today, I thought about just speaking to you all about estate planning. I'm not going to go in detail as to how to plan or how to set up a plan, but I just wanted to provide you with some basics as to what is estate planning, because I think that term just gets thrown out there and people don't really know what it is or what it means. And the question always is, do I need to have an estate plan? So I'll be talking about that, and I think there are some opportunity for a brief question and answer session. Hopefully we have some viewers out there and who are curious or have questions. All right, so estate planning. What is estate planning? Estate planning is really a plan that an individual sets up to let's see, the individual sets up a plan that lays out what should be done with their property upon their death. It also can be a plan to what to do in case a person or becomes incapacitated and can't handle their estate, their affairs. So the estate sounds like it's a big word, and sometimes I get people telling me, well, I don't have a real estate and I don't have a big estate. The meaning of estate for this purpose is just all your assets, everything that you own, all the personal property, real property, everything that you have and you are the owner of. You want to have something in place because you want someone to handle your things or take care of your things when you die and you're no longer here. So that is why you want to have a plan. Now, I am the opinion that everyone should have an estate plan, but perhaps not everyone needs a will. And there are different methods of transferring property or vehicles, if you will, that will get you to that point of having a plan where people can know what they should do when you die and you're no longer here to decide who should have your things. And the different ways of transferring your property also is that kind of the different options, I guess, that are out there kind of defines if you do need a will or if you need a trust, or also the size of your estate, all the things that you own and how they're owned. I think that also helps you determine how you want to give it away. The most common method, of course, is having a last will and testament. But if individuals do not want to have a last will and testament, and I get this frequently, they just want to make sure they leave their things to their loved ones or friends without involving the court. Under Nevada law and most of the laws of the most states, or if not all states, a person who leaves a will behind, the representative or executor of the will must go to probate court and lodge that will with the court. So people who want to minimize probate's involvement can leave their things behind in a way that probate might not become involved. and I'll get into a little bit more detail as to how to do that. But going back, I guess, to my point that there's different ways to transfer property or your assets, and that is done, again, by way of a will, last will and testament. An individual can have a trust with a pour over will, or there could be just by way of contract, and that applies to anything that can have a beneficiary designation. For example, life insurance policies, you could add a beneficiary, so that would be a transfer by way of contract law. Also, there is transfers of assets by operation of law, and that comes into play if there's a title. And if there's a title, there are certain ways to title property that will not require the probate court's involvement. So there's different things to do, different methods, different vehicles, and it's just up to the individual to decide what they want to do. Sometimes I do say that having no will can be an estate plan, and it's not the best option. But if someone dies without a will, the statute provides the order of preference, how things, separate property, if the person dies with separate property, or the person dies with no spouse or children, the law actually has a order of preference how things should be distributed. So if a person leaves things behind and didn't have a plan, things will get to the appropriate heir or beneficiary. It just might take a little bit longer. The other thing about that also, I guess it's important to say that if one wants to, I guess the advantage of having a will is that one can sort of change the default. The NRS, the Nevada Rights Statute, said, like I mentioned, it says, if you leave a spouse behind, they get X amount of your estate. If you leave a spouse and one child, if you leave a spouse and several children. So it tells you how to divide things. So if you want to change that default, then that's when the will could come into play and really accomplish that for you. So if you want to include your best friend Susie in the distribution of your estate, she's not an heir by law, but you can make her a beneficiary of your assets and your estate by naming that individual in the will. So that is an advantage of creating a will if you really want to give your things to non-relatives or people who are not heirs under the law. So I started the presentation saying, so an estate plan is just basically a map or to a flow chart to how to distribute your things when you pass away and you leave them behind. But in that same part of that conversation that I have a lot with clients is they bring up the phrase living will. And I just want to take the time right now to explain or make it clear that a living will is not the same as a last will and testament. They're not interchangeable, although some people do use it interchangeably. Living will can be part of your estate plan, but it has nothing to do with your things, your earthly possessions. The living will is also known as an advance directive or a power of attorney. And also in Nevada, it could be a standalone document regarding withholding of life-sustaining treatment. So a living will is really, what are your desires for in the event that you become incapacitated and you are on life-sustaining treatment, do you want to continue on life-sustaining treatment, or do you want that withheld? So if it's a standalone document, it could address that specifically, what you want. And then if you make it included as part of a power of attorney, it'll provide your desires, your wishes as to what you want if you were in that situation. And also the power of attorney may be a little bit more broad and cover other things like medical decisions. So a living will, I just want to emphasize that it's not a last will and testament. And also it's part of your plan because as we get older, we want to make sure our ducks are in a row, if you will. But we want to not only leave instructions for our things, but also what do we want for ourselves if we were in a situation that we can't make those decisions. And I know I mentioned the word or the phrase life-sustaining treatment. I just want to provide what the NRS, the Nevada Revised Statutes, how that phrase, that term is defined under NRS 162A.750. Life-sustaining treatment is a medical procedure or intervention that, when administered to a patient, serves only to prolong the process of dying. So in Nevada, that's very specific. So these declarations or living wills are about that, about what do you want? Do you want to receive this treatment just to prolong the process of dying? Do you want to continue it, or you want it withheld? So that, I think it's important to point out that that's really what these declarations for withholding or life-sustaining treatment are addressing. And of course, some people want to leave these instructions behind because at the time, if they become incapacitated, not only do they not want to burden their family with the decisions, but also this helps the family and loved ones and whomever's in charge of our agents to their healthcare decisions. They could have an idea as to what that individual needs. And lastly, I just wanted to kind of, I guess, differentiate also what the difference between, or differentiate what a trust and a last will and testament. A trust is also referred to as a living trust. I've heard that term used. I simply call it a trust, but a living trust, I guess it's appropriate to call it that because like a will, it's a trust is a legal document, but in addition to setting up a plan as to how to divide your property and your assets upon your death, the trust can be used to make decisions while you're living. So it's a live document that where you can provide instructions for how your assets should be handled, your estate during your lifetime, and also upon your death. So you could see why I guess it could be called a living trust, but a trust does come together with a pour over will, and that usually, without getting into detail, that is kind of like a catch-all. If you have assets and you transfer them into a trust, and then you acquire other assets and you forget to put them in, that could possibly catch all and make it part of your trust. But that is really all I'm going to say about that. So my goal today was to just put the thought, I guess, of estate planning in your head, you know, that you want to make sure, if you don't want to leave your things behind, you want to have something in place as to how to deal with those things. I was going to finish now, but I think I remembered I did mention Yet there are ways one can set up their property to avoid that infamous probate. So if one doesn't want to have a will, but they do want to have a plan in place that will allow their loved ones or their heirs, beneficiaries to get their things, there are ways to do that. And one way, for example, is anything that has a title. And these methods of doing this can be called will substitutes, because they are going to accomplish the same goal of getting your assets to your heirs upon your death, but it's not by way of a traditional last will and testament. So the most common document we use is if a person has property, real property. If you have property, whether you're still paying for it or not, you have a deed recorded at the recorder's office where the land sits. That deed is in your name, even though, there's still a mortgage, but that deed is in your name. The way you got the property was by way perhaps of a grant deed, meaning it was granted or sold, grant, bargain, or sale deed. So now, in order to get it to your loved ones in the future, when you're no longer here, there is a method of doing that, and that would be by way of a deed upon death. So a deed upon death is a deed allowed under the NRS, and it basically states that upon my death, I want my property located in X place to go to Joe Blow, who is my nephew. So I want to give my property to Joe. I don't want to have a will, and that's really the only asset I have. So I can draft a deed upon death, have that recorded with the recorder's office, and then upon my death, Joe can claim that property by going through the recorder's office instead of going through probate court. And that is done by, submitting a declaration confirming my death and providing evidence of that. And then Joe can claim that property. So that way I accomplish what I want. I want to give my property away upon my death, and I don't need a will to do that. So that applies if there is a title and that a deed upon death or work for property, real property. But also if I have, say I have a life insurance policy or an investment account or any type of financial account where I could add a beneficiary. I know when we open an account, they ask us, who do you want to name as beneficiary? Most of us don't know who, but I think this is something that anyone can, if you do have accounts now and you're thinking of having an estate plan, I would highly recommend for you to go into your accounts and see if you have a named beneficiary. The advantage of that, again, is that upon death, if I've named Joe as my beneficiary, Joe doesn't have to go to probate court to claim it. Because there's a beneficiary attached to the account, the asset becomes a non-probate asset, and thus Joe would be able to claim the account much easier than having to go to probate court. And again, if I just have a house and a financial account, I could get away with that being my estate plan. So, I mean, of course, I mean, I could have a will in the event I purchase other things, or there was an error that I didn't catch at that time with the deed. I could have a standalone will just to cover everything. But I mean, those are options that people have. And that is a way to set up a plan where you can minimize probate court's involvement. I guess I should also remember people own cars. Cars, like the deeds for property through DMV here in Nevada, one can also add a beneficiary to the title. That is a process not everyone is aware of or knows about, but I encourage you to visit the DMV Visa website, and there is an information there about transfer on death applications. You submit an application, you say, I want to add Joe to my title. The title, there must not be a lien holder. And then again, Joe will get the car when I die. They don't get anything now. And that's a way to avoid probate, and that's can be part of your estate plan. The advantage of all this, you know, to repeat the same, is that it avoids probate, but at the also all these documents are revocable. So I think that is all I wanted to cover today about what is estate planning, at least to get an idea of what that requires or what it covers. I believe at the end of the presentation, there's going to be links to, there's going to be a link to this video on our website. And I am glad we got a question. And the question is, does Nevada Legal Services do trusts? No, unfortunately, we do not handle trusts. So we wouldn't be able to assist with that. And I think that is, I'm more than happy to answer any questions anyone might have, any comments, jokes are good. But that is all she wrote on my part. I think we're just gonna, I think, let's see, what's it? We'll just, yeah, I guess we could end it now if no questions.